I'll go ahead and start with the first case, Shaw versus the heirs of Elliott Hampton. Good morning.
Good morning, Your Honor. If I may reserve 5 minutes for rebuttal.
Sure.
May it please the Court. My name is Robert Bauer. I represent the appellant, the unknown heirs of Elliott Hampton, and specifically Thomas A. Lee III, LOUISEMACK, and Louise Hampton as shown on the amended notice of appeal. This is a case about land. It's a case about equity. It's a case about fairness. This case is where a wealthy landowner has purchased a small portion of a family-held property. This owner convinced 2 splinter groups to give up their small portional share. Upon receiving deeds for these small portional shares, the wealthy landowner swept in with the court system and forced them to sell the entire property. This landowner wants to say that it is only fair that he can force a sale and a partition of this property so that he can get his just investment out of the property. It's not his just investment that he wants out of the property, it's the entire property that he's wanted, and he's used the partition suit to procure it.
Let me ask you if you agree or disagree with the status of the title as it's contained in the complaint and the judgment. In other words, the complaint and the judgment has a fairly long list of the folks that allegedly own an interest in the property. So my first question is, do you agree that the list of owners that the trial court found is the correct group?
Your Honor, we don't know whether it's the correct group or not because discovery has not been conducted on those issues. There hasn't been interrogatories. The family hasn't been determined. A full search of those issues haven't been done. The appellants were pro se in this action until the day before the summary judgment was heard. There has not been a full examination of the title and an exploration of who is the exact ownership.
Okay, so you don't agree either with the status of the title or with the percentages that are set forth in the judgment?
At this time, Your Honor, no.
Okay.
As I recall reviewing the affidavit, I know you questioned the validity or sufficiency of the affidavit that the other side filed, but in the affidavit that your client filed, the attorney filed, that part of the other side's affidavit is not contested at all as I read it. Is that correct? In other words, at pages 8 and 9 of the affidavit filed on behalf of the plaintiffs below, 8, 9, and 10, it lists the proportionate ownership that they believe to represent the ownership of the property. And in response, the responsive affidavit that was filed, I don't see that there was any indication that that was disputed in any way. Is that correct?
Your Honor, that has not been disputed in this case within the record. That is correct. As I said before, there was not sufficient time to be able to file an affidavit when counsel was brought on one day before the summary hearing.
Was there a motion to continue in order to prepare for the summary judgment?
I don't recall if one was, I believe, oral. Co-counsel made oral motions for continuances to file other affidavits, and I don't believe those affidavits were allowed to be entered.
My question sort of dovetails with Judge Lawson's. In looking at the affidavit filed by respondents McCoy, Walker, Cherry, by Attorney Hill, and are those the same folks that you're in part representing today?
Your Honor, I'm not specifically representing them in that the only clients that I have retained are Thomas A. Lee, LOUISEMACK, and Louis Hampton. However, they are all part of the defendants who are listed in the original case. So Their interests are represented by me today. They're not specifically my clients, but that is the group.
Well, I guess what I'm trying to figure out is the only affidavit that I saw, maybe there was another one, was by attorney Carol Hill. And that affidavit in opposition to the summary judgment motion said that the alleged that the parties named in the motion for summary judgment and the affidavit are the only parties of interest in this cause. There are no other claimants, lien holders, or interested parties.
Your Honor, that was a counsel who, while representing on the defendant's side, was not under my control of what statements were made, so I can't attest to whether his affidavit is factually correct as to who are the actual owners in this property.
Well, I guess what I'm trying to figure out is who's bound by that statement. You know, I guess what I'm trying to understand is the fight here about who are the heirs, who are the various owners, is the fight about we agree on the owners but we disagree on the percentages of ownership, or is the fight that we agree on the owners, we agree on the percentages, we disagree over whether the property is divisible, or is it about all of that stuff? And if it's about all of it, I'm trying to understand how those issues were raised in opposition to the summary judgment motion.
Your Honor, I would believe that at this time my clients that I specifically represent would agree with their proportional share, which comes up to approximately 30-some-odd acres of the property, whereas the appellee owns 15% of the property, which is 11.25 acres.
So just so I'm clear, your clients agree with the relative percentages of ownership that are set forth in the judgment?
Are you saying as to everybody or just as to your clients?
Your Honor, I can only speak as to my clients. The issue at hand also is whether or not even if the affidavit is correct, it is not sufficient in that it is an affidavit that does not provide a proper foundation for a summary judgment to be entered. The first appellate issue that was presented is in that the affidavit is insufficient because it was twice modified by saying that it was at the affiant's best of his personal knowledge and belief. This issue has been addressed by the Florida Supreme Court in 1953 in Hahn v. Frederick, where an affidavit that was originally submitted to the best of the affiant's knowledge, information, and belief was the key phrase that was addressed in the affidavit, and the court determined that such a statement that was made so far as the affiant's knowledge, these facts, it could be correct as far as the affiant believed, but it could be completely false. Hahn found that affiants must have knowledge of the facts and know them to be true, not believe them to be true. They must know it themselves. They further held that it is a well-settled rule that the facts of an affidavit must be stated in a positive and not qualified manner. It can't just be.
How do you address the argument that there's probably not anybody alive that's going to have knowledge of what happened in the 1800s and early 1910 with respect? I mean, we're talking about those kind of time frames with respect to this property. Somebody's going to have to research it and present the best information they can to the court, but I don't think anybody's going to be able to say, well, I was there and I witnessed the transfer of property in 1847 and in 1910, and I was there with the birth of the children, and so I know,
Your Honor, there's a different standard between the way that we view evidence as entered in an affidavit and the way that it's personally presented before the court. We hold a higher standard to affidavits because you can't view, the court can't see the individual, they can't see their personal inflections, they can't see the way that they react. When it's in court, we can have family members come in, there can be interrogatories and discovery that is done, that there can be family history that is available. It has not been determined that there's not family history showing what the ownership of these issues are.
Well, but again, I'm trying to come back. You indicated to me before, at least as to your clients, you are okay with percentage ownership interest that's been ascribed to them. Is that correct? And nobody else is squawking. So I'm trying to understand, even if there's some problem in, the derangement of the title, where's the, is this a no harm, no foul?
Your Honor, if I remember correctly, one of my clients, Ms. LOUISEMACK, may have some dispute as to the exact percentages. I believe it's fairly close. I believe there's some additional percentages that, but I don't believe that it's necessarily the exact amount. There's also some changes, I believe, in the percentage amounts that go from the original complaint to the affidavit as to what the different amounts are. I can't in good faith assert to the court specifically whether or not I feel that they're exactly correct or not. I unfortunately had not anticipated that question and don't have an answer for the court at this time.
Let me ask you this. The standard, the statute says 64061, that if the court is satisfied that the subject property is not, or the property is not subject to petition without prejudice, it can order the sale. If you look at those percentages and you see all of these 0.1% ownership interests, can't the court just look at that and determine that, something that's less, if you're talking about dividing, say, the 20-acre parcel into a lot of pieces that are less than 900 square feet, that simply is not going to be feasible without any additional inquiry? Why does there need to be anything else when you're talking about so many interests that are so small in that property?
Your Honor, that would be true except for the Florida Supreme Court holding in Schaefer v. Pickard, 77 Flaw 697 in 1919, where the Florida Supreme Court ruled a factual scenario that is very similar to the instant case, and the court reviewed where petitioners agreed that the partitioning party was entitled to a partition. There's no dispute to that. He clearly is entitled, even though we feel we don't agree with what he's done, he is entitled to it. However, they pled they wished to be able to plead that they remain joint tenants in common. The court required that because there had been an error in notice, that this be sent back down to the lower court. The petitioners had the opportunity to plead that, and if they pled it, the lower court must then grant the request to remain tenants in common and the other partitioning party to be removed from the property, which is entirely possible in this case. The appellee only owns 11.25 acres out of 75 acres. It is entirely possible, it's even probable, that 11.25 acres can be partitioned off of 75 acres. The Florida Supreme Court held that if a party requested it, it must be done. And while this was originally done by pro se representatives, there are a lot of allegations, requests to hopefully keep their property. In a letter that can only be characterized as an answer, in the record page 49, the fourth paragraph down, beginning right under the bold "for your consideration," my client, Thomas A. Lee III, says, "I'm in agreement that the property be partitioned. and I respectfully request the court to consider partitioning the property at the point adjoining the plaintiff's existing property line and leaving the remaining property and structures for the defendant's continuous use and enjoyment. It's contained in the pleadings that there was a request for exactly what we are asking to happen. The Florida Supreme Court says if there's been a request as such, it must be granted. I think application of the current statute would require that we send it to a commission of three for them to determine exactly where is the correct and equitable place to partition it.
Could you just again tell me who the answer that you were just reading was from who? Was it one of your clients?
Yes, Your Honor.
Okay. And I'm sorry, just give me the record site on that.
I have it as record page 49. It is the answer of Thomas A. Lee III, dated December 10th, 2003.
Okay, and you're into your rebuttal time if you'd like to hold on to that.
Yes, Your Honor, at this time.
Okay.
Let me ask you right off the bat, your answer brief did not appear to me to address the contention that the court has the authority to partition your clients out and just leave the remaining property. If that's true, I think you have a problem. So do you want to address that in the Schaefer case?
Yes, Your Honor. I'd say that the Schaefer case does not apply in this case. And the reason is the Schaefer case dealt, Your Honor, with 4 owners. And the one owner in 1919, it was partitioned into 4, there were 4 separate owners. And the owner came out, and from the very beginning, what he said is that I want my 25%. He alleged that. He wanted his 25% carved out. The other 3 owners never got notice of the commissioner or the report or anything else like that. There was a report that was done on that case. And what happened, Your Honor, was that the commission came out and it apportioned the other 3 parties' interest too. It never gave them any notice. They never got notice of anything. And what the court ruled was, at the end of the day, that it didn't change the result at all, that he was entitled, the plaintiff, to his 25% partition. But as to the remaining issues, since all 3 owners wanted to stay together, that they could stay together, if it could be done without partitioning, that they could break off that. That's distinguished here for a couple of reasons, Your Honor. Here, the defendants, they didn't have notice of it. They never got notice of either the commissioner report or the pleading or anything else that anything other than the 25% was going to be taken away. The commissioners did that on their own.
And how did they, when we talk about notice, we have a whole slew of unknowns and children. Tell me how the court obtained jurisdiction over them.
We published it, Your Honor. We spent 2 years before we did anything else. This is quite an undertaking. We went and we published to all these people. We also had a guardian ad litem appointed. And that's what we did. But getting back real quick to the Schaefer case, they had 2.5 years notice. It was never brought up before the court that these people wanted to do that. Also, there's one other really important factor, is that before you today, there's about 44 people. We spent 2 years investigating this, 44 equitable owners. I represent 3 of them. The property's already been sold, by the way, but I represented during the course of it 3. Mr. Bauer represented 3. That means that there's 38 parties who aren't represented here today. If the court speaks and applies the Schaefer case, they will be assuming that those parties' silence meant that they wanted to be co-tenants, instead of interpreting their silence to mean that they wanted this property to be sold, when that's all the information that ever came up. This argument was never made to anybody. It was never made to the court. The posture, Your Honor, of this case from the very beginning for 2 years.
Well, would the court have the authority to either petition your clients out and leave the rest there, or petition the 3 large owners, I think they own like 35 acres, out, and then sell the rest if there's no objection?
I think the court has the power to do that. Yes.
And I guess the other
But
question...
it was never brought up in this case, Your Honor.
But the other question is, does the court have the obligation to at least determine whether or not that's feasible? In other words, to appoint the commission, to take a look at it and say, well, we can carve out your 11 acres and we can carve out this, but all these people that have, a tenth of an interest, that's not doable, and so we'll take this chunk off here and this chunk off here, and we'll sell the rest. I mean, is that an option that, given the fact that we can't tell from the record whether or not it could be part, I mean, I agree with Judge Lawson that, when you see 0.1% of an interest, that's hard to think about partitioning, but when you have some of the bigger interest, it might be done given the nature of the property, which we don't know anything about. I mean, I guess that's really the question that I've got is, should the court have at least explored that, particularly when, as counsel says, one of his clients put that in his answer, pro se answer.
He did, Your Honor, and I reviewed it again this morning. It didn't stick to me, and I still don't really understand the language to mean that, and I think they backed into this case, but I think the answer is the court does have that power, but the court didn't do it in this case because it never considered it. I think it has the power under here to look and say...
But if you have one affidavit that says this land is not divisible, it can't be petitioned, and another affidavit that says we believe it can, which is what the court was faced with at summary judgment, doesn't the court at that point have a duty to explore it rather than just on a disputed issue saying, I find this is not divisible and going ahead and selling it?
I think, Your Honor, unless the affidavits are presented timely, or there's a motion for continuance filed, I don't believe the court has to consider those things. This case went on 2.5 years. The problem is that every dollar that is spent by commissioners and by appraisers and things like that is going to be deducted from whatever the value of this property is.
I can appreciate the practical problems, but the point that Judge Lawson brought up, I think, is a good one, and that is that your affidavit was met. I don't know if it was timely or not. It's in the record, and I don't see where it was ever stricken. It was met in opposition by an affidavit from an attorney Hill that says that the property is approximately 75 acres and is divisible without great prejudice to its owners. So you've got your affidavit saying it's not divisible without great prejudice, and his saying it is. So how does the court resolve that dispute on a summary judgment basis?
Your Honor, that particular affidavit was never provided to me or to the court. It was never brought up at the hearing. We understood at the hearing that there was no affidavit. There was no opposition, and I can represent that to the court, that we were under the impression, the court was under the impression there was no affidavits that were submitted prior to the hearing. It purports to have a file stamp from the clerk of the court of March 10, 2006. I don't know when the hearing was. The hearing, Your Honor, was...
And it was delivered...
It was January 20th, 2006, I believe.
Yeah, the certificate of service is January the 20th. It looks like the date stamp on it from the clerk of the court is March the 10th.
I believe, Your Honor, that the summary judgment hearing, and I'll double check it, was January 20th, 2006. And at that hearing, that was the first time we'd ever heard any opposition, or that I was ever aware of any opposition.
My guess is that I'm just guessing because I see that the summary judgment is also date stamped the 10th of March. My guess is that was handed to the judge at the hearing, and that when he did his final judgment, he sent it all down to the clerk, and it all got stamped, and then that's just my guess.
But I think, Your Honor, that the important thing is that they don't really have standing to make that argument because there's only 3 of them here. There are 36 owners who aren't represented here today. And if this court makes the decision that it's going to send it back for further study by the court, I think it's ruling that these people want to be joint owners, that they want to be joint owners with their client, and he doesn't represent them here today, that they want that rather than wanting to go ahead and have this property sold and realizing the money that's held in the registry of the court. Plus, they also have the standing. I mean, the issue of standing is that the property, they did file a motion for stay, but the court didn't stay it, and the property's been sold. The Shaws purchased it. And I think it goes with really a fairness. I mean, I think what this really comes to is this, Your Honor. is that the partition statute's been around since 1844. And it's a fairness statute. And in this particular case, it depends upon everybody coming forward and making their position and making it known. We came out and we did the best that we could. The statute says specifically, you got to say who the parties are, what the percentages are. You've got to say the names of the parties. We went further than that. We even put in there that from the very beginning we said it's not divisible. The percentages are too small. We did a lot of research on it. We put them in there, and we also said we want to put the whole property up for sale. That's distinguished from the Schaefer case where that fellow, the plaintiff, only wanted 25% sold. In this particular instance, everybody was on notice for 2.5 years that we wanted to sell the whole property. It was in our complaint. It was in our amended complaint. It went on 2.5 years before the motion for summary judgment. So I think this fairness issue comes up because now they come forward never having made one single argument to the court. I've never heard any of these arguments. The trial court's never heard any of these arguments about the affidavit or about that there wants to be joint ownership and that somehow, even though he only represents 3 parties, he wants to partition off our 15% and have his 3 clients be the ring.
Or they want to partition off their 35 acres or how much and let the rest be sold, one or the other, I think.
I think, Your Honor, that...
Sounds like that's what was attempted to be said to me in the answer that was filed by one of his clients.
I understood, though, in the brief, this is the first time we've ever heard the argument, but I understood the brief to say that he wanted our percentage. He wanted the court to look at our percentage, Your Honor, to be taken off. But the problem is, Your Honor, it's just a practical one. I think the statute gave the court authority. The statute gave the court authority to do what you said, Your Honor, which is he could have ordered a study and had the commissioners and spent the money to do that. But he also had the authority to go right to the section of the statute that says if he's confident in the allegations and judgment is entered, the court satisfied the allegation is correct, he can send it down to a sale, a judicial sale. And I think that's
so. It's your position that nobody appeared at the summary judgment hearing in opposition to the relief that was requested. There were no affidavits presented at that time. There was nobody present.
That's right, Your Honor.
You were there.
Yes, I was there, and there were people present. The opposing counsel was present, but no affidavits were presented. No affidavits were presented at that hearing. I never did get an affidavit, and so that's the first time I ever heard of any opposition was at that hearing.
If that's so, why didn't you mention it in your brief?
Oh, I did, Your Honor. I said repeatedly that there was no affidavit, there was no notice, there's no record, there's no anything like that. That was the main thrust of my brief. I meant to say, Your Honor, is that I never heard of anything about this before. There's been no record evidence other than our affidavit stating that the property is, that's what we contended the whole time. We never even knew. I never imagined anybody would come through and ask this court to partition the property. We never thought it was feasible. We laid it out in the very beginning. Our plan was to sell it at a fair market price and divide it, because some of the interest goes from 0.1% to 20%. And my affidavit was carefully drafted because, like Judge Lawson, like you said, I thought I was the person that had the best information and belief, and that's what the statute says. You've drafted under best information and belief. The statute, our case is distinguished from his that he cited because the affidavit there dealt with Chapter 38, and that's a removal of a judge. And in Chapter 38, it specifically says it must be based on actual knowledge to have a judge removed. My affidavit, based on knowledge and belief, is exactly what the allegation says I must make under Chapter 64.
Well, let me ask you, you say the first time that you knew that there was any opposition was at the summary judgment hearing. In what form was that opposition presented to the court? Who argued? What did they argue?
They stood up and they argued that they wanted to have a continuance. There was no argument about any ownership or anything else. Nobody, to my knowledge, to this day has ever contested our percentage ownership, the names of the parties, the amount of money that we were trying to get, the value of the sale. They stood up at the hearing, no court report or anything else, and they said they wanted to have a continuance. And there was no affidavits presented at that time. At that time, I wasn't aware that any affidavits other than mine had been filed. No one had ever. I'd gotten calls from people, I know it's in the record, but saying that they wanted to lay low on this case because they thought even one of his clients even admitted in her answer early on that it couldn't be partitioned. One of his 3 people even put that in the answer. So I never even understood that. The court never understood it either. So all these arguments are brand new to us. And what I'm saying is that I think after 2.5 years, we spent a lot of money on the case, and we tried to get it. We viewed our job to be looking after these people and to do it as quickly as possible. I mean, to do it cheaply. And we went beyond the statute. We put in there that we wanted to sell it at a fair appraised price, and we even upped it because the property values. When the case went on so long, 2 years for me finding all these people, that we raised the value, the appraisal went up. But we didn't have to do that, but we put that in there so it would be a fair price because it's an equitable statute like opposing counsel pointed out. But no one, we were completely unaware at any time until the day we walked in fact, until I read the brief, that anybody had a problem or it was suggesting.
Well, you still have the burden of showing that there's no material issue of fact and that you're entitled to the relief that you're requesting as a matter of law, correct?
That's correct, sir.
And what we have is an affidavit that says that you depose to the best of your personal knowledge and belief, and then there's a recitation of the ownership. But there's nothing that even identifies the basis for that knowledge and belief. There's no indication that any search of the records was made, that any information was obtained from any source. And frankly, the thing that concerns me most is the conclusory statement that this can't be petitioned without great prejudice. Because this is apart from the personal belief of what the relative percentages are, there is no fact in this affidavit, not a single fact. Why couldn't it be petitioned without great prejudice?
I think, Your Honor, it's like some of the case law where they talk about living where husband and wife have a house together, and they say, well, obviously this can't be partitioned, you can't live in it together. It's the same kind of thing. If you've got 44 owners, Your Honor, some of them going from 0.1% to 20%, you've got landlocked property. It's out in the middle of nowhere.
I don't know that it's landlocked property. I don't know that it's out in the middle of nowhere. All I know is that you say it can't be partitioned without great prejudice. That's all that's in the affidavit.
I think that's right, Your Honor, and I think that stems from the fact until the second that I walked into that courtroom for the summary judgment, I never knew there was any opposition.
But it's your burden to demonstrate those things on summary judgment. And it seems to me that, as Judge Griffin pointed out, that your statement in the affidavit that it can't be partitioned without great prejudice is not a fact, it's a legal conclusion. What concerns me about the affidavit is not so much the on knowledge and belief, but it's the lack of any information that would lead us to understand how you came by that information. For example, obviously land title records, the normal course of business would be to search the land title records in the courthouse or have an abstract or a title company search it. All we know is all of a sudden we've got this lawyer filing an affidavit that says, here's the heirs of all these folks. Well, but we don't know where any of that comes from. Now, obviously, I'm sure you didn't just make the stuff up. I'm sure that you did a lot of work to have this done. But doesn't the plaintiff here have the burden of demonstrating in the affidavit how all that got done? I had a search of the public records done by the Acme Title Company. It revealed that, according to the public records of Putnam County, Florida, the ownership is vested as follows. I'm an experienced lawyer, and, we rely on the public records in making title determinations. It seems to me that that's how you put those sort of facts out there when you can't have personal knowledge. I mean, you probably don't know all these heirs and weren't around in the 1800s and all. And isn't that how you have to put the affidavit out there so that you have facts and not just conclusions?
Yes, Your Honor. I think it is. I think that is the way, and I wish that I had written it like that. At the time I wrote it, I didn't have any opposition, and the day of the hearing, I didn't have any opposition. I think the only answer that I have to that is there's nothing on the other side. as far as I was concerned. Even to this day, I didn't know that there was anything that was opposing. And to answer Judge Griffin's question, if there had been an affidavit that was brought up at that hearing, then I wouldn't have gone forward and asked the court for that relief. I would have brought it up that there was a conflict. And I thought to this day, I didn't know that there was an affidavit that was opposing. We did do all those things. We worked very hard on that. I'm sorry the affidavit doesn't reflect that, but it should. It would be a better affidavit if it did.
Well, I appreciate your candor.
But
And maybe I've just missed it, but, because I'm just reading here quickly, but I never picked up in your answer brief your contention that you didn't have the affidavit. I mean, the initial brief relies on it. Your answer brief, I don't remember saying, hey, I didn't have that affidavit.
I'm sorry, Your Honor. I wish I could point right to it, but I mean, I'm about out of time, and I'll be out of time. But I'll represent this court. I had never had any knowledge to this day, if I'm standing here today, that there was any affidavit that they had filed at any time. And I don't believe that one was ever timely done. If it was filed, it would have never been presented at the hearing. It wasn't presented by the opposing counsel. I didn't know about it. I don't have it. I was not aware of it. That's one of my big thrusts in this whole thing, is that they never made any arguments. They never would have. The only record evidence is my affidavit. And so if the court finds there is other record evidence that's involved, then I think the court, my only answer is mine is the only evidence that was valid, that was timely filed. If the court finds that there is other evidence, then I would agree. I wouldn't object.
Well, I'm sure counsel for the other side will tell us candidly what the answer to the question is, which may just leave us with the question of whether the showing that you made in your affidavit is legally sufficient. That might be why that's the main thrust of their argument.
All right, counsel, thank you so much.
Thank you.
Well, why don't we start where we left off? Tell us a little bit about the affidavit. I understand that the hearing was January the 20th. The affidavit from Mr. Hill, although file stamped March the 10th, which is the same day that the final judgment is file stamped, has a certificate date of January the 20th. So tell us, was that affidavit before the court, and if so, was it timely, and if not, was there any motion to strike it?
Your Honor, as I recall, and I'm sure that counsel has shown that he's very candid with this panel in attempting, I recall a different set of facts of what happened at that hearing, is that Attorney Hill attempted to present an affidavit at the hearing itself. The rules of civil procedure do provide in a summary judgment that a judge may, even if they are not provided the 2 days delivery before or mailed 5 days before, that the judge of their own initiative may deem it proper to bring that affidavit in. I think, Judge Orfinger, you have properly articulated what probably happened is that that affidavit was passed out at the hearing, and then at a later time the judge decided to incorporate it into the record with his ruling. I have no personal knowledge that that is exactly.
Were you at the hearing?
Yes, Your Honor, I was at the hearing, and we did present the argument at the hearing that we believed. I presented the case law Schaefer as to that we wish to have, first of all, because...
Do you have a record of what happened at the hearing?
There was an attempt to have an audio tape made, but apparently the equipment at the courthouse failed, and there was no court reporter present for the hearing, so there is no record actually of the hearing. However, I believe I could get a statement from Attorney Hill as to whether what happened if the court would require that. I made the oral argument that we wished to, at shooting for the moon, having the 11.25 partitioned off and leaving the rest of the family together. There's, I believe, to be insufficient discovery done in this case to find out what the feelings of the unknown heirs are. There's family members who know who these unknown heirs are, and they have not been deposed. There's been no discovery on it.
When was it a suit filed?
The suit was, I don't have the original complaint, but I believe approximately 2 years prior to the time of the summary judgment is the correct articulation. I don't believe that any discovery was done of them, nor any interrogatories were filed. My review of the very large files at the, I did not see any, nor see any in the docket.
But 2 years is certainly enough time for your clients to have done that if they wanted to, correct?
Your Honor, it's not their burden to find out who all the defendants are.
You can't require the other side to conduct additional discovery. If you wanted to conduct discovery, you certainly could have done it within 2 years.
Well, and if you didn't think that the attorney or guardian ad litem was doing his or her job to protect the unknowns, you could have brought that to the court's attention. So I'm not too impressed with that argument.
Yes, Your Honor. As far as the partition issue not being brought up prior to the summary judgment, that's not correct. It was contained in an answer. It was clear that there were members who wanted to keep their property. I believe it's contained in the record. And present, we do have, attorneys often have a practice of sort of blowing off pro se answers because they are chaotic and difficult to understand how they actually apply to the complaint sometimes. However, I believe that sentence is there and for pro se representative clearly articulated that he wished to have the portion that was contiguous with the plaintiff's property cut off from the side.
All right, counsel, thank you so much. You've exhausted your time.